All right. Good afternoon. My name is Wendy Benverlow. I'm the Executive Director of NAPSA, and as always, it is my pleasure and honor to be here with you today. Really excited about the session that we have today. We have some outstanding national pretrial experts who are going to go through some of the real fundamental pieces of what it means to have a pretrial system and to support pretrial justice. Thank you all for being here so promptly. I just have a couple of announcements. First off, if you've been on the website and you registered for this event, you know that we don't have any other webinars currently posted. We do have one, though, that is in the works, and I'm hoping to have posted within the next few business days. And so if you want to kind of pencil this down, our next session will be scheduled on July 15th, same time. It's a 1 p.m. Central Time start. And the topic is going to be overdose prevention with the CDC Foundation Overdose Response Strategy Team. And so I'm excited for you to see that one. Again, July 15th, 1 p.m. Central will be the start of that. The other big thing we have going on, in case you didn't hear already, is that we have our conference registration ongoing right now. Conference is going to be in Reno, Nevada at the Grand Sierra Resort starting August 30th, and registration is open. We currently have early bird pricing running through July 20th, so this is a great time to sign up and save a little bit of money on your registration fees. To note, on Sunday of the conference, we are having two special leadership focused sessions. One will be on kind of like an office culture, office wellness. You can find more information on our website. I will post that here in the chat in just a second. And then the other session is coincidentally going to be a big expansion on this current session. So this is kind of an overview of one of the really in-depth sessions we're going to have on this Sunday of our conference. So I'm excited for you to see a preview of that. And registration is still open for that. So the link I'm putting in the chat right now is where you can find out more information. And we hope that you'd be able to join us in Reno. And with that, I will again say thank you so much to our panelists, a bunch of excellent folks and colleagues. And I'm going to turn things over to Janice Dean.
Good afternoon, everyone. My name is Janice Dean. I am the Northeast Regional Director for NAPSA, and I'm also the Criminal Court Administrator in Pittsburgh, Pennsylvania. And we'll have Kelly Bradford introduce herself.
Good morning, good afternoon, wherever you're at. My name is Kelly Bradford, and I am the current past president of NAPSA. And I am also the Court Services Director at the Administrative Office of the Courts in New Mexico. And with that, I will turn it over to Sean.
Thank you, Kelly. Good afternoon, everybody. My name is Sean LaGrega. I am the Deputy Director at Maine Pretrial Services, and I also serve as the Secretary for the NAPSA Board of Directors.
Thanks. Just before we get started, I just want to give a little bit of context on why we decided to do this webinar, and also the full day framework for pretrial justice, essential elements of a pretrial justice system and agency at the conference. So for years, there's been about, I don't know, maybe 50, 60% of the people at the conference are first-time attendees, relatively new pretrial workers. And so a lot of times they pick to go to the fundamentals. Sometimes with the fundamentals, it's hard to put all of that into context and to figure out what fits where, when, and how that all really fits together to this. So our thought was that we would do a one-day pre-conference for really new pretrial employees. It could be anybody, right, coming into pretrial. It could be line staff. It could be it could be a new program, and you bring your program people. So what we thought was putting this together really gives context for when you then go to the conference, and we think that you're going to get a lot more out of the fundamentals of the conference, understanding where all the fundamentals fit into this continuum. So with that, I think that if you have questions, oh, okay. forget it. Wendy already put that in the chat, I just noticed. So if there's questions, then you just want to put those in the Q&A section. Okay, so getting bail right. One of the things that we talk about a lot is really thinking about that initial decision. So courts process millions of criminal cases every year, and each requires a judicial officer to determine if a defendant should be released or detained pending trial. This is one of the most important decisions in criminal case processing. However, most judicial officers do not have a lot of information, sometimes no information, or appropriate release and detention options available to make the best bail decision. Moreover, systems lack the structure needed to monitor release defendants, screen detained defendants regularly for release eligibility, and safeguard individual rights and community safety. This presentation is really going to address the elements that need to be in place from both a system and an agency level in order to do bail right. But first, we need to talk a little bit about the history of bail and why we find ourselves here. So really the impact of pretrial detention, and this is a study from November of 2013, and it still actually holds true today. There's been a couple jurisdictions that have done this same study, but compared to defendants released at some point prior to trial, defendants held for the entire pretrial period had 4 times greater likelihood of being sentenced to jail, 3 times longer jail sentences, 3 times greater likelihood of being sentenced to prison, and 2 times longer prison sentences. So when you think about that pretrial detention, and people that were released, and they looked at similarly situated defendants who some were detained pretrial, whether they couldn't make a bail or there was some type of detention decision made, and people that were similarly situated in terms of criminal history, charge, things like that were released. That's what we're talking about. We're talking about the same type of people. So really, as a criminal justice system, we should try not to do harm. But a lot of times when we don't have the correct information, judges don't have options available to them and really know why they're setting bail, that we'll end up doing more harm than good. And we can look at impacts of pretrial detention in 2-year recidivism. So this is for low-risk defendants that are 2 to 3 days in jail, and sometimes, depending on how your jurisdiction even does first appearance, sometimes first appearance doesn't even happen for a day, day and a half. So 2 to 3 days on low-risk defendants increases their 2-year recidivism by 17%, 4 to 7 days, 35%, 8 to 14 days, 51%, and 15 to 30 days, 46%. So they controlled for similar level charges, prior criminal histories, were really contributing to poor outcomes, especially for low-risk defendants. And if you're not assessing pretrial risk, you don't know who low-risk defendants are. And what ends up happening is people are looking at the risk level of a defendant based on the current charge and not what their actual risk level is. So now I'm going to turn it over to Sean.
Thank you, Janice. So what did the first generation of release look like? This was the running out of personal sureties that really led to the first secured bonds and the use of commercial bondsmen in this country. And as a result, too many people were being held in jails, unable to make the release due to not being able to pay the bail amount. So in response to the success of jailing, reformers looked at measures like OR or PR bail. Scholars started to implement research. The Manhattan Bail Project and the Vera Institute were on the scene. And what we saw was the creation of the first pretrial service agencies in this country.
So the case that most closely identified with the first generation of bail reform was the Supreme Court case of Stack v. Boyle. And a lot of us have heard about this case, and it's from 1951. This case was during the height of the McCarthy Red Scare, and Loretta Stack was a waitress in San Francisco and a secretary for the local Communist Party. She and 11 others were arrested and charged with conspiracy to overthrow the U.S. government. They were each given a $50,000 cash bond bail. They argued that was wrong and that they should not have all received the same bond. And the Supreme Court agreed, stating that that people have a right to bail, there needs to be an individualized release decision. It should not be arbitrary. And so those were really important concepts that came from the Stack case, which is one of the foundations of the pretrial work that has happened over the last 50, 60, 70 years. That the right to bail should not be an actual right to release, and release should be the norm. And that's a big one, and we'll talk about another case. In Stack, the ruling was the judge didn't take the circumstances of each individual into consideration, and that 50,000 was just pulled out of a hat, was excessive and arbitrary. And so really what that ruling was about is really looking at each person as an individual, looking at their circumstances and making decisions that are based off circumstances of whether they were going to return to court. And so Stack v. Boyle, if you're not familiar with it, is one of the fundamental frameworks in our pretrial justice system.
So these are really the three things that came out of Stack. The release decision should be individualized and not arbitrary, as Kelly said. All right, we're going to turn it over to Sean.
So what did the second generation of bail reform look like? And that was detention. It was really sparked by individuals getting out and committing new crimes. The first generation of bail reform really didn't take up the issue of detention or being able to hold people for legitimate reasons. And people really started to think about whether or not we could detain somebody on a risk or a presumption that they may do something in the future.
Yeah, I think one of the things that sometimes people sort of overlook is, what does your detention statute look like in your own state, right? So sometimes when we ask that question, people are unsure, and you should really know. Pennsylvania has a preventative detention statute for not only cases that would require someone spending life in prison, but for dangerousness. So some states have a dangerousness clause in that, and there has to be a hearing. So there's, safeguards on that, but you should really know what your preventative detention statute looks like in your state.
So the next major Supreme Court case that really impacted our field is U.S. v. Salerno, and this case closely tied to second generation in the United States versus Salerno. Fat Tony Salerno was a mafia boss who was charged with numerous crimes, some of them of violent nature, some of them not. And the government argued that there should be a compelling government interest that would allow for a person to be detained. And the U.S. government agreed, but indicated if you're going to use detention, it must be carefully limited and include procedural safeguards. Detention is okay in some cases, but it really must be carefully limited. Using money as a means to detain is not carefully limiting that option. And when detention is used, it must have procedural safeguards. And we'll talk a little bit more about those safeguards in the next couple of slides.
This is the famous quote that comes from Salerno. In society, liberty is the norm, and detention prior to trial or without trial is a carefully limited exception. And this is a quote that we've had in place for well over 30 years. And it really makes us question, when we look at our individual jurisdictions or places around the country, where are we with this quote? Where do we sit?
Yeah, I mean, thinking about how does your jurisdiction detain people that it thinks should be detained? And most of the time when people are asked that, most judges are detaining people by setting money bail that they think they cannot make, right? which is dangerous because if you want someone in and you set a money bail that you think they cannot make, and then they make it and get out, then what happens, right? So it's not the outcome that you're looking for.
So what does the third generation of reform look like? And it really was sort of a goal to figure out how to strike a balance here. And, whenever things go too far in one direction or the other, a system really tries to sort of right itself. So now in the third generation of bail reform, trying to find what is the happy the Goldilocks situation. How do we balance the rights of the accused with compelling government interests?
So what basically, whenever the wrong people are in or out of jail, we end up with bail reform. So when you have high-risk people being released, you're going to end up with bail reform because something's going to happen, right? Someone's going to get out, they're going to do something. When you have low-risk people who are being detained, then you're looking at increased money, right? So, I mean, I don't know what it is in your jurisdiction. Our jurisdiction, it's $186 a day to keep someone in jail. So when you have these people that don't need to be in jail, you're spending a lot of money that is taxpayer money that you really don't need to spend. So when you end up sort of backwards, where your high-risk people are getting out and your low-risk people are being detained, however that ends up happening, whether that's by charge, whether that's by judicial decision, but then you're going to end up with some type of bail reform. And cash bails come under scrutiny in many places. And really, it is the legal framework in most states, right? You're going to see New Mexico, Indiana, like some of your New Jersey that really sort of tried to move away from cash bail. And as those things happen, there's lots of attacks on what's happening, and there's a lot of blame being placed, and it's really led to lots of lawsuits. We're going to talk a little bit about how these lawsuits are being filed and what they're being filed for down the road.
And so I love the sign, no waiting, we get you out fast, bail bonds, 24 hours. However, the system that we have in place with cash bail, it has come under challenge. Quite specifically is the use of cash bail. And we have to keep in mind when we use the word bail, bail doesn't mean money. Bail means release, no bail means no release, but we often associate it with money. And so that's where a lot of these lawsuits have come from across the country really over the last 10 years. And really, financial bail should not be used to hold defendants. When someone goes before the judge and bail is set, in theory, release is being set. And if something is preventing that release, such as cash bail, then that person is being preventively detained. Cash bail may also be unconstitutional, and it can lead to biased outcomes for those who have access to money versus folks that do not have access to money. And so these lawsuits have been filed all across the country in all sorts of jurisdictions. And the interesting thing about all these lawsuits is they're winning, and systems are having to very quickly change the way they operate. And this was something I'm in New Mexico that I was looking at when we first started our work, is how do we get ahead of it so we get to develop our system and we don't have a federal opinion or something coming in and telling us how we're going to do those things.
Oh, I'm sorry. I thought there was a question. Okay, I'm going to move on to the lawsuits.
So here is a list of many of the lawsuits, and there's been a few more probably since this list was put together. And if you're interested in keeping up with these lawsuits, we have a comprehensive list that can be found through the University of Michigan Civil Rights Litigation Clearinghouse. When these suits started to crop up around 2010 or so, we basically, were alerted to this. So we started looking at it and we started taking note that they weren't just filing these lawsuits, but they were winning. And they thought it in New Mexico, that's what I was worried about. I thought that we would start to see these before we could make some of the instrumental changes that we made to our constitution and our legal framework. But this is really a list that everybody should take a look at, kind of look at what the findings were, what the original cases were that brought these cases forward, and really take notice of it. Because if you don't think it can happen, it will happen. And these lawsuits have really in many cases, haven't changed the laws in the United States. They've helped remind us of what it should be.
Yeah, I think almost everybody is, aware of sort of the Harris County, Texas, where there was, one of the largest county jail systems in the country. And I mean, their jail went from, I think, 13,000 to like 8 after this, and with no noticeable increase in crime, increase in appearance rates and things like that. So sometimes, right, your system is not going to change until it's forced to change, right? Systems don't always think like, wow, let's see if we can save the taxpayers money. Let's see if we can, get some of these people that don't need to be in jail out of jail. And so sometimes being forced to do it, and Harris County has maintained their lower jail population, again, with no increase in public safety or appearance rates.
So just to kind of summarize what the major issues were, and we always continue to look more in depth into the specific findings of the lawsuits. But financial bail should not be used to hold defendants. Cash bail may be unconstitutional because it leads to bias within our systems for those who have money and those who do not. It's really important as practitioners in the field that we understand the history of bail and the generations of bail reform that we've already been through if we're going to make any meaningful systematic change. And so bail decisions are release decisions. Reasonable bail must consider the defendant's ability to pay, must be individualized to that particular defendant's risk. So, over blanket conditions, those types of things. And they should not be charge based. Someone's charge doesn't really dictate really what their risk of picking up new charges or missing court during the pretrial phase actually is. Bail schedules are unconstitutional. So jailhouse bond schedules, those are unconstitutional. Due process guarantees applied in the application of preventive detention. Bail conditions must be tied to court appearance or public safety and be least restrictive. Oftentimes we'll see conditions that are being applied and they really look more punitive. They look more post-adjudication type conditions versus what are the minimal conditions that we need to put in place for this individual to make their court appearances and not pick up new charges. And conditions imposing financial costs to a defendant may be illegal. And that can even include, someone who's being ordered to a type of supervision, such as maybe EM, and they're required to pay for it. Now we've created another financial burden to them being released. Jurisdictions' resources are no excuse to deny rights associated with bail. And so that's something that if you're developing or enhancing or changing your pretrial justice system, one thing that we did in New Mexico is we do have some level of GPS that is used throughout the state, but we're very clear with the courts through funding and stuff, they cannot require a defendant to pay for GPS. The court has to find the money to do that. So those are the big major issues that have come out of those lawsuits that has really made us not just rethink how we do what we do, but really address it under a legal and evidence-based perspective.
Yeah, and I mean, that's absolutely true, Kelly, especially with, things like you talked about electronic monitoring, GPS, things like that. But also you see a lot of jurisdictions that use alcohol detection devices. So maybe interlock or scram devices, things like that. And if that is a pretrial condition, one, you need to show how that's going to affect court appearance or public safety. And two, that shouldn't be on the defendant to pay for that. Even urinalysis testing, right? Yeah. Many jurisdictions go back and forth on that. And a lot of times people either overuse urine or urinalysis testing, or use it for something other than what it is. Just taking a test and knowing someone is positive, if you don't have resources for an evaluation or some type of treatment, the urinalysis isn't doing you any good, right? And are you charging them for it? One of the other big things on this list is bail schedules. And so lots of jurisdictions either use a jail bail schedule, where jails are allowed to release people on certain amounts of money in certain types of cases. So it doesn't matter what the circumstances of your case are. If you have a simple assault and your criminal history looks like this, you can pay $5,000 to be released, right? That's not individualized. It is also, the Supreme Court has also said bail schedules are unconstitutional. Bail schedules can be used by like jails. I've seen jurisdictions where their judges have a bail schedule. So if someone has an aggravated assault, it's $10,000. If someone, and there's nothing even, it's only charge based. And so those were a lot of the impetus of some of these lawsuits, where people were using charge based bail schedules, right? So now you've got not to be charge based and bail schedule, and you have a bail schedule that's charge based, you can get sued. And so, you know, like Kelly said, they were winning a lot of these suits. There is a question. Is there any data regarding individuals concerned, and if they are suffering substance abuse disorder, homeless, unemployed, or any behavioral health, mental health issues? I'm assuming, Eric, you're talking about those things being risk factors for non-appearance and new criminal activity. I'm assuming that's so. There is, so when substance abuse, mental health, when that becomes a risk factor, right? Then you look at addressing that risk factor. Not everybody that is homeless or has substance abuse is gonna get new charges or not show up. So if you have prior information, so if I was on pretrial release prior to this, I had a drug problem, and I didn't show up because I was afraid I was going to be drug tested or whatever reason, then that becomes a risk factor for me. So then what is the option? The option would be that some jurisdictions will go ahead and make a bail condition that you have to go to treatment. What we are putting forth in both the NAPSA standards and what most jurisdictions are doing is offering supportive services. And we talk a lot about supportive services not being something that you're offering, but that you're not ordering, right? So it's a distinction, right? That is relatively subtle, because people are just like, well, if I want them to go to treatment, if I don't order them, they're not going to do it. And that's not always the case. So until some of these things become a risk factor, you don't know if they are or not, and they have to be addressed after. You're never going to end up with 100% success in anything. And when you start to look at unsuccessful outcomes, new arrests, or non-appearance, then you would want to start to address some of those things. But prior to that, from initial outset, what you don't want to do is like, okay, this person admitted to have a drug problem, or their charge was a drug-related charge that you're assuming is from a drug problem. So you're going to put, no alcohol, no drugs, random urinalysis, go to inpatient treatment. They might not even qualify for some of those things. So what we have been putting forward is that what you should do is offer supportive services. On the back end, and we'll talk about this, in a few minutes when we talk about sort of the agency elements, what your agency has to offer in terms of supervision and how that is sort of put forth when you are getting people on supervision, whether that's in person, whether it's by phone. Since COVID, everyone uses a lot of video, but there are things you can do to offer people stuff that if they need it, they get it. If it becomes a issue, then sure. We have found here, and we've looked at this a lot because our judges were always very concerned with the homeless population not showing up. As a matter of fact, they show up just pretty much at the same rate as people that are housed. And so we have not seen that. And that's really something, like when you're talking about some of these things and when you're talking about, what works, what doesn't work in terms of getting people to come back to court and remain arrest free, we know a couple things. We know that, court reminders work. We don't know, right? Does electronic monitoring, GPS, does any of that stuff, does that work? There's really no evidence that shows that it does or that it doesn't, but sometimes it can get higher risk people out of a jail setting and into the community where they can then, mount a better defense, and see what happens from there. So when you start to think about some of these questions, especially in your jurisdiction, if you have the ability to collect data on some of these things, it's great to be able to do that. And then back end to take a look at it and see really, because it's going to be different. Different communities have different resources, have different available resources for people to go to. So what you have, what you offer, is really going to help you figure out what works. And that is one thing that's lacking in the pretrial space, is that we don't have a lot of research on what works to mitigate certain risk levels.
Yeah, Janice, that's great. And I'd like to just add, for us as a field, risk mitigation should really start to look like supportive services, and how do we network the individuals that we serve to resources in their communities? Because the list of issues that were in the question, those are really common questions. Like, are these things linked to increased risk? I think we really need to start looking at that list of potential risks as public health issues, and how do we as a field start to assist in addressing those public health issues for the people that we serve?
And I would add that, because I really like the concept of, supportive services, voluntary supportive services, because you can have someone who's struggling from all or most of those things that were in that question. But if they're showing up to court and they're not picking up new charges, then the question is how do we get them to engage in services, maybe for future betterment of life? But we don't need to make them right now, because they're showing up to court and they're not picking up new services or new charges. We used to see that all the time in one of the programs I used to oversee. And there was this natural reaction of, but they have a problem, but they're homeless, but they're this. And so we definitely want to help people, and we want to help people have better lives. But again, the goals of pretrial justice, we call it the 3 M's. We want to maximize release, we want to maximize public safety, and we want to maximize court appearance. And if they're hitting those things, now how can we get them connected and engaged? But right now they're being successful on pretrial.
Right. I think that's one of the, and there's a good paper we can probably put it with this PowerPoint when we post this stuff. But there's a good paper that Tim Schnacky did on the differences between pretrial and probation. And so I think a lot of times, probation is looking at longer term changing behavior, and looking for people to do better, not come back. At pretrial, not that we don't care about long-term success, because we don't want to see people come back. But what we're looking at right then and there is that they show up for court and they don't get rearrested, right? If they don't have a high school diploma, I don't think that getting their GED, right, is a good condition. It will help. It could help them down the road. But for pretrial, we're very specific on what we need to do. And we have to be very careful, because when we start to over condition, that's when you see people fail, right? So just think about if someone told you you need to show up for court and don't get rearrested. You're like, I think I could do that. I know what my court date is. I just got a reminder, and I'm going to steer clear of whatever got me in trouble last time, whether that's drugs, alcohol, people, places, things, your normal stuff. But if I tell you, you have to not get rearrested, you have to show up for court, you need to get your GED, you have to have 3 clean urinalysis in a row, you need to go and get a mental health evaluation, you need a drug and alcohol evaluation, and you need to write me a letter to bring back and tell me why you shouldn't be a criminal, right? All of a sudden, you're like, what the heck? I mean, when I get convicted, I don't even have that many conditions. So I think we just have to be aware of that. And that really comes with a lot of education for your bench, for your pretrial staff, for your whoever needs to know in your stakeholder group, right? Whether it's the district attorney's office and the prosecution who wants lots of conditions. If it's your defense bar, they want no conditions. And so, there has to be some type of happy medium there to get people back to court and remain arrest-free. That's what we're concerned about at the pretrial stage.
And Eric, welcome to NAPSA, and we love questions, so don't be a stranger.
Yeah, absolutely. Ask as many questions, and we can actually we'll move on here from this, but some of this stuff, it's not that we will answer all of your questions, but we'll at least give you some information in terms of where you can go to get some of this. But so the essential elements, can you see that slide?
No.
Because it doesn't appear to be.
There you go.
Because it was one of those. Yeah, I did notice that. Sorry, people. So this is really what the 1 day, full day seminar will really focus in on is the framework and the 4 dimensions for your essential elements. So legal basis, standards, research and evidence-based practice, and organizational theory. So everybody knows legal basis, like what are your laws in your state and what do you have to do to comply with that? Standards for pretrial release and diversion, NAPSA has standards, ABA has standards, and NAPSA's, we're currently working on diversion and release standards, and the last iteration of the NAPSA pretrial release standards was 2024, and we are working on getting out probably in 2026 some amended standards that won't change a lot. But I mean, the NAPSA standards had not been revamped when we did it in 2020 for probably like 20 years or something ridiculous. But so our goal now is to, every couple of years, make sure that we're adding in new practice, new research, things that come out. So, and then organizational theory really is, so how does your organization function? Who in your organization comes? So you're talking about staff, customer satisfaction. So, I'm always amazed when I talk to people and I say like, hey, listen, if you're in a meeting like with your district attorney, your prosecution, your public defender, like what comes up with that? And people are like, oh, I wouldn't, like, I don't even know them. You know what I mean? So a lot of these things, and we're going to talk about, the system elements, a lot of these things, sometimes we take for granted, especially in jurisdictions where there is a lot of collaboration between all of the stakeholders, that happens. And so, when we talk about this stuff, we want to make sure, and it seems basic to some of you because you already do this, but some people have no idea who like how to even bring all of those stakeholders together to hear about what you're doing. So the definition of bail, and Kelly had talked a little bit about this, but requirements to reasonably assure defendant's appearance in court and where appropriate public safety. So there are some states that only have an appearance. So New York only has an appearance. And then so basic tenets, there is no right to bail in most states, and the federal system in about a quarter of the states or so, there is that because defendants can be detained pretrial either through legislation that identifies who can be detained pretrial. Sometimes it's really just capital crimes where the proof is evident and presumption great, but the federal system, DC, New Jersey, Pennsylvania have bail can be denied for following a detention hearing for dangerousness. Also, non-appearance, you can actually do that. But really, your only two constitutionally valid purposes of bail: appearance and public safety. Okay, so what we're going to do now is we're going to go through all of the system elements and then the agency elements. And what I would, if you have questions, absolutely put the questions, and one of us will try to get to those questions as we're going through this. So the first thing, when you're talking about your system, you're talking about pretrial as part of the system, and pretrial release and detention decisions should be based on risk. And so getting your system stakeholders to understand what pretrial risk is. It's risk for non-appearance, risk for public safety, and getting that information out there is imperative for your system to know exactly what you're doing. That a lot of times in jurisdictions, people have no idea what a risk assessment is. If you're using a risk assessment. So when you're talking about your system as a whole, you need to make sure your system understands what a risk assessment is and what it is not, right? It's not saying that Kelly Bradford is going to do this. Basically, a risk assessment is saying that people that have the same characteristics as Kelly, same criminal history, same charge, are going to, on the majority, act like this. So you need to make sure that everybody understands what this is, and that detention and decisions are based on risk and not charge, or someone you don't like, or someone that your community thinks is a pain in the neck, and so they're like, just hold them because we just don't want them out there.
So then the next one is the legal framework that includes a hierarchy of options. And so every state is going to have a little bit of a different legal framework, and your hierarchy of options are going to probably be different as well. And so like in New Mexico, everybody in New Mexico under our law is presumed releasable. And the only people that can be considered for detention in New Mexico are people who are charged with a felony. And then that has to go through a preventive detention hearing in which a DA must prove through clear and convincing evidence that this person is a public safety risk. We do not look at detention for purposes of court appearance, of public safety risk. And then for everybody else that's going to be released, we have a hierarchy where we must start with those least restrictive conditions. And the first one is release, OR. And it can then go all the way up to high levels of supervision, GPS, and all those types of things. So really understanding what legal framework you're working within and all the mechanics of that legal framework, who's releasable, who's not, and of those, how does that release look? In New Mexico, we cannot use financial conditions except for purposes of court appearance, and they can't be at an amount more than the defendant can afford to pay. And if they're sitting in custody for more than a couple of days, we have to have a hearing to have that condition either removed or that amount reduced. So really understanding your legal framework and how release and detention works is really important.
Yeah, and I think the next is, does your jurisdiction have release options following or in lieu of arrest? So what types of conditions could be imposed on that individual prior to release? Are there options for supervised release? So really making sure that you know what's available within your system and that there's a wide range and that those options are individualized to that person. We have a question in the chat. Do we want to take that real quick?
Yeah, I was just looking at that while you
Okay.
were talking. And so the question was, so our system seems to lean on the maximum requirements like mental health, drug and alcohol assessment, follow recommendations, 1 to 4 visits with their pretrial officers monthly, clean your analysis, get a job, sometimes curfews. As a pretrial officer, it seems like I'm always on the fence about violations or am filing violations. Should I approach my supervisor to talk to our judges about these topics? Thank you. So a couple things there. So I think that, like we said before, a lot of that is sort of judicial education. And the nice thing is this year will be our first year at the NAPSA conference where we are going to have a specific judicial track, right? That'll address things like this for judges. Once we've been talking about that for many years now, and we're getting it off the ground, and we're very excited. We have 5 or 6 judges who are very vested in this and are going to be teaching this to other judges, which is really something that we found is very helpful when getting judges information, is that other judges give them that information and sort of buy into this. And I mean, Kelly has lots of judges that come to the conference every year, right? And they sometimes feel like they don't have enough stuff to sort of help them out. So this is really going to be exciting for NAPSA and for the judges. And, hopefully we can talk to Wendy at some point about maybe figuring out, you guys can invite some of your judges and we can do a judicial webinar, right? Which we have historically not done. And we can get some of our judges maybe that are helping us with the stuff. So one thing I think is education. The other thing is, I think that when you're talking about violations, I think that has to be very clear from your court on what they want to see as violations, right? So early on in our program, we decided that, and we got the blessing of the court, and we talked to them about it for a really long time with, all of our stakeholders involved, in that if someone gets a new arrest or fails to appear, then we will go ahead and let the court know that. But if they were supposed to come to pretrial on a Monday and they show up on Friday, or they don't show up till the following Monday, we do not issue a violation. But everybody understands what violations we're doing, like what violations that we're submitting to court and what we're not. So I think that there's room in that for you to move away from violating for certain things, right? When you get, and maybe it is go to your supervisor first, and then maybe they go to their, whatever you call it. We have a criminal justice advisory board. Some people call it, different things, but that's a good place to bring up stuff like that after talking with your either presiding judge, your administrative judge, whoever would kind of be that judicial decision maker. But yeah, I think that there's room to move on that. And then as you move on that, then you sort of try to get them to lessen conditions and let pretrial, like if you want them to get like an assessment, get the assessment, and instead of like putting all these other conditions, if they want to do an assessment, follow through with any treatment recommended, right? And so that leaves it to the treatment professionals and not a judge to sort of determine that someone needs to go to inpatient or intensive outpatient, which you can't tell by looking at someone, FYI. I mean, I don't know if you guys knew that, but it is absolutely the truth. So I think that answered the majority of the question. Do you guys see anything else in there or have anything else to add to that?
I would add, when you're working with judges to try to start moving judges to conditioning differently, it's a culture shift. And because, judges truly are trying to do the best job they can, and they really have the idea of public safety in mind. And so we have a culture that, the more that we can make someone do, we really do think that we're, putting public safety first. And sometimes there's not an understanding that, requiring someone to get a job, well, the job market might not be that great right now. It might be really hard to find a job. And so now we've created a condition that's tied directly to one's liberty and on whether they're employed or not. And so really looking at those conditions, and it takes time, it takes education. I mean, we've been doing this for years in New Mexico, and we still have those conversations with judges that really throw down all of these things for an individual to do, and we've set them up for failure. But that wasn't the intention of the judge by any means. So it takes time and culture shifting your system away from these types of practices that will, ultimately you'll have better outcomes, but it takes time.
Yeah, that's a great point, Kelly. I think it's also really important that agencies and organizations have the ability to mitigate technical violations in a way that makes sense. Pretrial practitioners should not be filing blanket motions for things like missed curfews, missed appointments, failure to attend treatment. Those are the technical violations that we should be able to work with an individual to try and get them to a point where they're complying with those requirements.
Especially if they didn't show up for a treatment appointment, but they went to court the day before and they have not been rearrested, right? It's getting back to like your basic tenet of why you are in existence, to make sure that people show up for court and don't get rearrested. So hopefully that answered the majority of your question. But we're happy to, if you have any follow-up. So our next is bail eligible defendants are considered for release with no locally imposed exclusions not permitted by statute. So I can't tell you how many jurisdictions I've been to when they're like, oh, we're not allowed to do a risk assessment and recommend release for someone who has a gun charge. I'm like, oh, is that in your state statute? No. But, like in making these decisions, they decided gun charges, nah, we're not going to touch those. Like they'll have to stay in jail. Anyone who's eligible for bail by statute, which in almost every jurisdiction is everyone except, right, capital cases, that you should really not exclude from, whether it's from doing a risk assessment or making a recommendation after that risk assessment. I know that if you're arrested for a homicide in my jurisdiction, you're probably not going to release, but we still do a risk assessment, because guess what can happen, right? You go to the preliminary hearing in 3 days and they're like, oh, sorry, this wasn't the person that actually did the shooting. This was this. And so we're going to amend the charges. We already have a risk assessment. We can give it to the judge right then and there. Here's what we have. These are your charges. And again, if you're looking at charge-based, right, that's where you're going to end up in trouble, because most of the exclusions that we see are charge-based. Whether that be, I've seen jurisdictions where you are not allowed to interview, make a recommendation, or do anything on a DUI case for 72 hours. Same thing, I've seen it on domestic violence cases. And so what you need to make sure is that your pretrial program is interviewing and doing a risk assessment on everyone who is eligible for release by statute.
So then the next one is experienced prosecutors screening criminal cases before the first appearance. This one is really important, and unfortunately where I'm at, we haven't quite figured this one out yet because the way our system works. But really having prosecutors look at these cases before they enter the system. Because when all the cases get pushed into the system, then you have someone who has a case pending, maybe they're in custody, whatnot, and it takes about 6 months for the prosecutor to finally realize, I don't have a case, and then maybe the case is dismissed. And it can really clog up dockets. It can really be a clog in the entire system. So having prosecutors early on reviewing those cases, making sure it has everything that they need to take the case forward before it comes into the system, before first appearance, really creates a stronger system. And then you also don't have folks that are sitting on pretrial supervision or in custody for months and months and months, only for a case to get dismissed. A great example I have of this is several years ago, I used to keep a running tally of everybody that was sitting in our local jail for longer than 60 days. And we had this gentleman that was in on a 4th-degree felony. I think it was like residential burglary. He was in jail for 792 days before his case got dismissed. And that was one of the examples that we ended up using to kind of make some of the moves we did. But if the prosecutor would have maybe reviewed that case a bit earlier, and waited for the investigation to be complete, whatever, before they brought the case forward, this individual wouldn't have sat in jail for 2.5 years before the case was dismissed.
Right. Also, if you think about how many times that initial charge is overcharging, right?
Yeah.
So, we see it all the time here. Like, robbery is a felony 1 case. People are very worried about robbery. Then you read the affidavit of probable cause and you're like, it was ex-boyfriend, girlfriend, grabbed the cell phone. That's different than like, I just robbed you at gunpoint, right? So there, a lot of overcharging happens because they want to have some room to deal and make a plea agreement on the end. So if you have prosecutors screening those cases, a lot of that stuff gets weeded out. And then some of those people will get out of jail. Some of them will take a plea to a summary case or something, right? Where they're not sitting in jail, like, Kelly said, for 2 years waiting for this to come about.
So the next one is defense counsel active at first appearance. I feel like this should be two separate sentences. It should be defense counsel at first appearance, and then it should be active defense counsel at first appearance. Counsel should be there to represent the individual, but be making an argument. And we know that systems operate differently, but it's always mind-blowing to me that when I learn about a jurisdiction where defense counsel isn't present at first appearance. So there needs to be that representation to assist with the argument for release rather than detention.
Right. We have, when we first got defense counsel at first appearance, it was our public defender's office. And after a year of having them there, we did, the Vera Institute came in and took a look. And our release rates with active defense counsel at that first appearance, where there's a liberty decision being made, our release rates went up about 30%. But even more interesting was that the racial disparity went almost to nothing, right? Where prior to that, when money bail was being set, of course, a lot more people of color and people without means were being detained, whereas when defense counsel was there, they were getting released at a much higher rate. So it actually was twofold for us. It really worked out well. Next would be the collaborative group of stakeholders that employs evidence-based decision-making to ensure a high-functioning system. So we talked a little bit about this a couple different times during this presentation, but getting your stakeholders together and having them understand exactly what you're doing, exactly what they will do in response to you, whether you're talking about violations, whether you're talking about prosecution at first appearance, defense counsel at first appearance. Everyone needs to know. You need to know, how are you sharing that risk assessment, right? How is that going to be used? What does your statute say about using that information? But making sure that the group knows exactly what everybody's doing is really helpful in down the road getting rid of any type of complaints, lawsuits, all kind of different things that it really avoids when everybody knows what everybody else is doing, and that you're really bringing evidence-based practices and you're getting your data to them on what's happening in this situation, what's happening, what your success is, what your failure rate is. You know, we have a dashboard that anyone in our stakeholder group that we give access to can go onto the dashboard and look and see that last month, you know, we released 4,000 people, and of those 4,000 people, 3,800, right, showed up for all their court appearances in that month. They can look at that by month. They can look at 6 months, right? They can filter it out. But just so we're very transparent on that. In some months, our numbers just aren't that great, right? Like our success rate goes down and everyone's like, what are you guys doing? Like, what's going on? Like, let's get together and talk about this, which is great. Like, I want them to be involved in what's going on in this and really being part of the solution, because then they're vested in it. Their employees are vested in it, and everything just seems to flow a little bit better.
Yeah, and I'll just add, in a lot of jurisdictions, they're known as criminal justice coordinating councils. And it's really a great venue to bring all of your stakeholders together to not only issue spot, but solve issues. And if anybody's looking for a good resource, you can go to the National Organization of Counties. There's a full page of resources for starting and maintaining a CJCC.
And then the last one on here is a dedicated pretrial services agency. And this is really important. And we're going to get into some of the components of that. You know, a lot of, ideally, you'd like for your pretrial services program to be dedicated. So a program that's not trying to do both probation and pretrial, because probation and pretrial really are two different worlds. The goals of pretrial are going to be different. It's, you know, maximizing release, court appearance, and public safety. Probation, it's about accountability. It's about long-term behavioral change and those types of things. So they're really two different fields. However, we know that, you know, due to funding, how different programs are funded through counties or state or local governments, oftentimes you're going to see pretrial and probation kind of under the same hat. And it can cause problems, because then people that are technically pretrial or folks that are probation, they oftentimes get treated the same. The same strategies are used, the same type of violations are used, and they're really two different places. So we get it. You got to start somewhere. And so if you have pretrial kind of sitting under probation, it's a place to start, but ideally, eventually you want to have a dedicated pretrial services program all to itself, because the way you deal with pretrial individuals is going to be very different than what you would do on the post-adjudicated side. Because remember, pretrial is not about accountability. It's not about a punitive type, sentencing type conditions. It's really about getting people to court and not picking up new charges. Where post-adjudication, completely different legal status. People have lost some constitutional rights through the finding of guilt, and they're looking at really long-term behavioral change.
Sorry.
It's okay.
I was
So
reading the chat.
So this next slide really looks at sort of what are the best practices for our pretrial organization. What are the elements of a high functioning pretrial agency? And the first one is an operationalized mission. Do you have a mission statement? Do people know what it is? Do people know where it is? Do they understand what the mission and the values of the agency are? Is that mission statement looked at and reviewed on a routine basis? Mission statements change because they need to, or they should. So I think it's really important that everybody has an operationalized mission statement and they know what it is.
Yeah, agreed. And even if you're, like Kelly said, like one of the system elements is that you have a dedicated pretrial agency. If you don't, right, you want to make sure that if your pretrial agency is under a larger parent umbrella, that pretrial agency has its own mission statement, right? Even if it's under probation, it's going to be a completely different mission statement than probation, you know, when you're looking at that. when we talk about universal screening, this was part of the system element in that there's no exclusions to who you screen. The other thing I wanted to say about this is that pretrial programs should screen everybody, even if you know they're not going to be released, whether it's because there's an exclusion, whether it's because, but screening everyone gives you lots of information, right? That you can, you'll see at the end here, you're talking about performance measurements and feedback, right? But the screening, the more information that you have, especially when you start to combine that with outcome measures, right? Gives researchers, if you have your own researcher, that's great. If you're using, an external partner, whether that be, but universal screening gets you a lot of information that can go towards helping us figure out what actually works in mitigating this risk when you are getting this pretrial misconduct, especially violent pretrial misconduct, is so rare that it's really hard to determine what that looks like. And I know a lot of people use the PSA and there's a violence flag on that. There's lots of, risk assessments that talk about that have like a violence indicator. But again, some of those things are so rare. And so by universal screening, you can start to combine all of that information into something that can help with to make your risk assessment more accurate, and that really helps with feedback on and performance measurements. So you should screen everyone, even if your jurisdiction does not allow you to present that. You still should gather all that information for any number of reasons. In a week, charges could change and they could be eligible, and then you have all that information that you can then present quickly to get someone out of jail faster.
We have a validated risk assessment tool. And so ideally, like Janice said, you're going to want to use it on everyone, but it's really important that you use a validated risk assessment. Validated means that it's been studied. It's been looked at. It's been found to be predictive or not predictive, depending on what tool you're using. It's been validated against possible bias in the tool. And so, I've worked with jurisdictions that have kind of created their own tools. There's a lot of tools out there that are free for use that have been validated. But even if you create your own tool, you do need to move to have it validated to see, is it predictive? Is it biased toward a certain group of people that you're not aware of? And so Janice mentioned the public safety assessment. That tool is probably the most validated tool out there that I know of, unless you guys know of something different. And it is free, and it's a fairly easy tool to use. It doesn't require an interview, although some jurisdictions really benefit from that interview. But make sure if you're going to use a risk assessment, it needs to be validated. Or if you have one that you've been using, hopefully you've been collecting data on it, you need to move to validated.
And Kelly, I'll just add on that one. If and when you are using the validated tool, it should be revalidated at least every 10 years. Okay.
Yeah, agreed. I was just going to say, we have a locally validated tool that we have, and we have historically revalidated about every 5 years. And there's a really good, Wendy can maybe put in the chat, but there is a good paper that talks about risk assessments and especially when a lot of jurisdictions are complaining, or maybe not your pretrial program, but sometimes your stakeholders are complaining that risk assessments are biased. But NAPSA did a really nice sort of meta-analysis of risk assessments, their validation studies, if they were looked at for bias. So I believe it's on the NAPSA website, but Wendy can correct me if I'm wrong.
Right.
No, that's actually a really good paper then. I think it is on the website.
I think it is too.
I just put it in the chat.
Yeah.
Just put it in the chat. Thank you. Sorry.
Thanks, Wendy. So the next element is sequential bail review. What does that mean? It basically means that you know who is in your jail that has not made bail or has not been released post initial appearance. And does your agency or organization have a process to return to speak with that individual to see if there has been a change in circumstance, to see if there are maybe contacts they'd like you to call. Maybe they want you to call a parent. Could be any number of things, but it's the process of going back in to see if you can get to a yes in terms of assisting somebody with their release. Really important that agencies and organizations have clear policies on how to do this. Definitely easier to do in more rural jurisdictions, a little more challenging to do in larger jurisdictions or metropolitan areas. But it's a critical component of a high functioning agency.
Yeah, absolutely. I mean, we because the jail, right, bears the brunt of people that don't get out after initial appearance, because of course then they're tasked with housing and medical and all the stuff with that. We had our jail create a list of people that were only in there on a bail condition that they could not make. And so every morning we run that list to see who didn't make it out the day before. And then we contact them through the jail counselor. And, we could ask some additional follow-up questions. Maybe the judge at initial appearance said like, hey, if they have somewhere else to live except with the victim, right? So then we can follow up with them like, hey, do you have somewhere? Yes. We can put it back in front of the judge that day and they can get out. So it's not a one and done. You want to make sure that you're, monitoring this, because it is part of really what you should be doing to get as many people safely released as you can.
And I'll just add to that. My organization, we have a policy that we need to go back and speak with individuals at the 48, 72, and 2-week mark if they still haven't secured release.
Yeah, I mean, that's great, because that gives really definite timeframes, and your staff's aware of when they need to go back and do it. And, that's really good. I might steal that.
Well, it's easy to do in Maine. Some of our jails only hold 30 people.
Yeah, I guess that would be a little bit easier. So your next agency element is risk-based supervision. Again, if you're going to do universal screening and a risk assessment, have this sequential bail review, you have to offer some type of supervision. I think that pre-COVID, we had the majority of our people were once a month, they had to report in person. Post-COVID, completely flipped, right? The majority of the people are either phoning in or they can use video conferencing, different things like that. So, but you need to make sure that you have some type of supervision to mitigate that risk. And what does that look like? And everyone can't be placed sort of on the same thing. And you also want to make sure that you have the ability to either reduce after a certain time period. We did a study about 2 years ago now, and that 80% of the people that had pre-trial misconduct either got a new charge or failed to appear happened in the first 45 days. So we took all of that information, we packaged it up, we made it look pretty, and we got it to the judges, and we asked them that, hey, listen, if people make it 50 days on supervision, instead of coming monthly, can they just come in on court dates? And we're like, 80% of the people fail in the first 45 days. And they were like almost unanimously, absolutely. So what we do now is, if you make it 50 days and your case isn't disposed of or hasn't been, the case isn't over at that point, then we will reduce your supervision to just court dates only. So you would only have to come in when you had a court date, let us know what's going on. And other than that, if there's any issues, then you can phone in. So just knowing things like that actually helps with your risk-based supervision, because we would have never, had we not collected that information, we would have never known that the majority of failure happened within the first, 45 days or so.
So, Janice, that was actually a great segue to the last one, performance measurement and feedback, which is my favorite because I'm a data nerd. And I have learned over the years, really the gift and the tool that data can be, because your data tells a story. And so just, what Janice was talking about is, they use data to show what was happening in their system and how they could make a system improvement to get to a better outcome. And that's really why it's so important to be collecting data and measuring everything and anything that you can. Because then you can use it on the state level. I use data all the time when I go up to the legislature and they're like, the PSA is bad or whatever. I can show them data showing, well, before we implemented what we've implemented, these were our outcomes. And since we've implemented everything we've implemented, public safety has gone up across the state. To measuring length of stay. How long does it take from the time that a defendant has gone before the judge for the initial liberty hearing to when the release actually happens? And we know from research, the longer someone stays in custody, especially low to moderate risk defendants, the larger impact it's going to have on future criminal activity. So there's so many things that you can use your data and your performance measurement and feedback, taking it to your local stakeholder groups to show them what's happening in the system. What are our public safety rates? What are our court appearance rates? Hey, if we implement a court reminder system, will that improve court appearance rates? So you collect the data and more than likely it will. So it's a way to, one, always be transparent about what's happening in your system. It's a way to analyze your system and try to find improvements in your system. I had a jurisdiction where I was looking at public safety rates for their highest risk defendants that had been released. And it was probably one of the lowest public safety rates I've ever seen for that risk group, maybe ever. And it made me immediately think, is the DA using their tool of filing preventive detention for some of these individuals? And when we went and we looked in the last year, the DA had only filed 2. And I was like, well, we need to go talk to the DA and show this data to them. They need to be using their tool of filing preventive detention on certain defendants. So they started to do that. And we saw over a 6-month period, their public safety rate increased by 10%. And that's a lot statistically, especially in a small jurisdiction. So really, make sure you're collecting data. If you don't know what to collect, there's great documents out there. Measuring What Matters tells you what do you need to collect to calculate a public safety rate, a court appearance rate, a success rate. It's all out there, and you can always reach out to us at NAPSA because there's a few other data geeks on our board that we'll talk to you for the next 12 hours if you let us on statistics, although I hated it in college. Never thought I'd have to deal with it, and then here I am. So this is a really important tool that you can use with your local jurisdictions, your local stakeholders, yourself, to measure how your pretrial program is doing internally. So this is a really important measure to be looking at. We implemented this thing, so what's happening?
Yeah, agreed.
I don't want to jump in, but I did, before it gets away, there's a question that's kind of going up in the chat. It's from Melissa LeMay. Her question is, I am interested to better understand why the vPRE revised cannot be utilized with an FTA warrant arrest.
I am not sure, but Melissa, I absolutely can email someone from Virginia. I'm sure they would know. But I will definitely find out and we will get that information to you. So at least I know with our locally validated tool and the PSA that it's for a new charge, and it depending, right? An FTA warrant arrest, is it always a new charge, right? So if it's a new charge, you can use it, but a lot of jurisdictions don't charge the charge of FTA.
And I think you're right, Janice, from having used the vPRE revised in the past in jurisdictions that I worked in, it's because the validation occurred on a new charge, not on a failure to appear in court.
Yeah, I think I'm pretty sure that's why, but I will double check. And
I believe that's the way it is with us as well.
Yeah.
Because the FTA is it's a violation of a condition of release that is to show up to court. So it's not a new charge in itself.
All right. Well, we're very happy that you came today. And if you are interested in sort of the expanded version of this, we will be doing this, the three of us, at the Sunday of prior to the NAPSA conference starting. But if you would, if you don't mind, if you would go and rate this session. And it's always nice for us to know what people want and like. Don't like, that's perfectly fine. But it's we want to provide what you guys need. And so we can, if you would do the evaluation, we would appreciate it. If there's any questions, we're happy to stay on. If not, this is the end of the presentation that we have, but we're happy to stay on for questions if anyone has any.
Yeah, I'll make a couple of statements to give you all a chance. In case you want to add any questions, you can add those to the Q&A feature, although it looks like there might be one more message that was just added. Oh, just a thank you. Thank you, Adrian. If you do have any questions, please go ahead and put those in the Q&A. I am going to share just a couple of resources. There's been a couple of people asking about the slide deck and also about the video recording for this. Yes, we will be sharing those. Typically, that takes me between 24 and 48 hours to get those uploaded to our website. I put the link in the chat. And you'll actually, if you go to that link, you'll find all of the videos that we've done in the past, and the vast majority of them also have a slide deck attached to those. So it's a bunch of really great resources and some training material if you would like to use it. So anyway, that is in the chat. And then also just the reminder that we are doing registration right now, early bird registration for our conference. Janice mentioned this was just kind of a preview. This hour-long session was a preview of a day-long intensive session that will take place at Sunday of our conference. And so you can find information at the link I just put in the chat about registering there. Hopefully you can join us. It's a beautiful facility out in Reno, a beautiful area. And as well, we are trending toward really high attendance. And so we're excited about all of us being able to get together and, be in the same place with all of our colleagues. It's always a treat. Again, if you weren't here at the very beginning, our next webinar is not yet announced on our website, but you can get the information here first. It's going to be July 15th at 1 p.m. Central, so go ahead and pencil that in. What we are currently working to schedule is on overdose prevention with the CDC Foundation folks, the overdose response strategy. So July 15th, 1 o'clock. Again, such a wonderful pleasure to have all of you here with us today and to learn here from these wonderful pretrial experts. I'm so grateful to Janice and Sean and Kelly. And seeing no more questions, do you guys have anything else or feel like I've forgotten anything?
No, but thank you all for coming, and I hope we can see a lot of you in Reno.
Yeah, thank you all for attending.
Thank you.
All right. Thank you all. Have a great day.